The Common Core project, I think, is a very important and interesting project where you, in a conscious way, try to develop comparative law in a sense that is useful for practice and for research and future research in commercial law and other law areas. And the Common Core method, where you take concrete situations and fact situations and ask how would this problem be solved in different countries, in different legal atmospheres. There you have a possibility to develop comparative law and to develop the understanding of how you can solve different problems that are common for lots of jurisdictions. If you talk to private practicing lawyers, they work with comparative law, they work with conflict of laws, and they need to understand each other and to understand what the problems are in a different jurisdiction. And therefore, studying it in a sense that you have it already during your legal education, I think it's very important.
Comparative legal research is a very important element when it comes to strengthening the law faculty's international profile. And I would say that most colleagues are very open to this kind of studies, and we also try in many ways to encourage comparative studies, for instance by arranging international conferences and through exchange programs. Any colleague who is interested in comparative legal study have a great possibility to pursue such research at our law faculty, here or abroad.
A very good example of how the Common Core method can be used and can develop comparative law is legal researcher Caroline Haug from Norway, who had her dissertation this spring in Amsterdam doing research in comparative property law. She used this method in order to investigate and research the question of transfer of ownership in different jurisdictions in Europe. A conference like this is very important to all of us. People who are working in different places, maybe working alone a lot, they need to have a discussion and a possibility to meet and to discuss, especially with these last couple of years of isolation.
All right, then I think we have everybody here now. Dear colleagues, welcome to the first session of the 27th General Meeting of the Common Core of European Private Law. My name is Kelly Chen, and I'm a senior lecturer here at Stockholm University. And I've been part of the team organizing this conference here at Stockholm. And I will also serve as the commentator during this session. And since Professor Ugo Martier cannot participate on site here today, he has graciously given me the honor to chair this session as well. So I'll be wearing different hats, and I will try to say a few words in these three different roles. And if I can start with saying a few words about the experience of organizing this conference. And I will put on my hat as a co-organizer. I have to confess that it has not been a very easy task. Maybe even quite a challenge to make this conference happen, to plan a conference as this in the midst of a global pandemic. But today, when I was looking at the list of participants, I felt such a joy because we have successfully brought together participants from 24 countries across 4 continents, joining us here today in Stockholm, but also online. So in this sense, I do believe, and I would like to agree with the Vice Chancellor who was speaking before, that this kind of hybrid format of conference organizing, it might be the future of academic gatherings. And if I can continue to say a few words as an organizer, I think that maybe the possibility to gather like this, to bring together people from around the world, is more important than ever in these times, in these extraordinary, difficult times that we are in. Because our topic today is indeed the common core of European private law. But as we all know, law is essentially a reflection of the values we share in our society. So, in our search for the common core of private law, it is also a quest for the common values that we share and stand by in Europe, but also in the global community. And now I'm going to switch and wear the hat of being the chair of this session. I would like to say that we have the great pleasure to listen to a couple of really fascinating presentations today. When discussing the topics with our speakers prior to the conference, I started to think about the evolution, the trajectory of law, how it springs, evolves, and maybe even contribute to the common core of private law. But I will not reveal too much, and I will leave it here. You can see it as a cliffhanger. In terms of the order of this session, we will have our speakers present first, and it will be followed by a few comments from me. And then we will have a short break, and then the Q&A part. And as you can see, we have two speakers with us today. And Mimi, though, can unfortunately not participate today due to sudden illness. But she has sent me her PowerPoint presentation that we have copied, printed out, and please take a copy. And I do hope that we'll get the opportunity to listen to her talk another time. I have had the pleasure to listen to her presentation about the evolution of the Chinese contract law, and I do believe is quite a fascinating topic. So we will have first Kristina Ramberg, who is professor in private law here at Stockholm University. And then we'll have Alexander Helgat, professor and chair of private law, corporate law, and jurisprudence at the University of Regensburg. And without further ado, Kristina, please.
Thank you, Kelly, for this introduction. I was extremely honored when I was asked to give this presentation to the project, The Common Core of European Private Law. But the main feeling is really not to be honored, but a feeling of nostalgia. And the reason is that in the mid-90s, I participated in a project on pre-contractual liability. And I was in Trento, and I listened to Hugo Mattei, and I was very young, and I was very happy. It was a project filled with joy. And it gave me new insights. It was almost, to me, a revelation how our differences in our respective jurisdictions are they're only different in a very shallow surface. If we go deep, we see how very alike we are. And this revelation, this insight, has formed me very much when I went back to become a national researcher in contract law. Because once you've seen the comparative aspects, I'm very much like what Hugo said this morning, that don't care too much about how you do the comparative work, just do it. I like that very much, because once you've seen the comparative possibilities, you can never go back. And once you've seen how things can be solved in other countries, you get a much deeper understanding of your own national law. So, and this was to me extremely rewarding, and I'm so very grateful for this experience. Now, I'm a contract law lawyer, but in later years, I've had, it's just contract law. But in later years, I've had a new insight, a new revelation, a new understanding of problems. And that is based on it refers to the sources of law. Now, you all know that in common law countries, Anglo-American countries, they say we're based on case law. Precedents are the main source of law. Whereas in civil law countries, legislation, statutory law is the real source of law. And we have all learned this is a great difference. Great difference. And when legislators, when they create a new rule, a new statute, they think very carefully about stuff, about how this rule fits in, how to make the best rule. They consider deep principles, historic origins, how it fits into the legal system, and they create the new rule. Judge-made law, the way judges make rules, is different. They do it on a case-by-case method. They consider, well, now we have a dispute. How shall we solve this individual dispute, vaguely having in mind how that may influence all other future disputes similar to this one? But the judges, they don't have all the time that the legislators typically do. And they see only the individual case. But on the other hand, they see the individual case, which is perhaps not as easy for the legislator to do. Now, the thing that occurred to me looking to Swedish law is that we have always perceived ourselves as based on legislation, statutory law. But when it comes to private law, that is not true. We have the perception of being a civil law country based on legislation, but in fact, within the area of private law, we're not. We have, in effect, become based on precedents, on case law. And this is a great challenge to us, since we don't know how to deal with precedents. We don't understand how precedents become rules and how to deal with these rules in precedents. I'm looking at my Scottish colleague, and you're smiling, and you know that you've been for many hundreds of years been discussing this from the very start of your legal studies. That's what you focus on. Typically in Sweden, we have had very little focus on how to understand precedents. Okay, very, very fascinating. Now, it turns out that this is not only something happening in Sweden. All over the world, we see how civil law countries, traditionally based on statutory law, are developing precedents, case law, as a very important source of law. And these countries are, like my own, trying to cope with this new source of law. of course, everybody said, well, it's kind of important. We have referred to cases, but the reason for that is not mainly as a source of law, but as an interesting illustration. We use cases as illustrations, not as sources. And now, all of a sudden, we need to look into the cases as rules, judge-made law. Take, for instance, a country such as Brazil. And Kelly, I don't know whether we have any Brazilian participants, do we? No. Okay, so then I dare say something about Brazilian law.
Oh, we do.
We have, here in the room. Oh, then you have to correct me if I give a wrong representation of Brazilian law. But to my understanding, it used to be in Brazil that presidents, they were forbidden to be used as a source of law. They were not acknowledged as a source of law in the Brazilian constitution. Then all of a sudden, not too long ago, 10 years or something like that, the Brazilian constitution was changed and now says presidents are binding. A total reversal. And from what I understand in Brazil, they don't know what to do. What is a binding precedent? Can we never deviate from it? And to what extent is it binding? For lawyers, this is really, really hard to deal with. China, now unfortunately we don't have Amy Su here to present Chinese law, but in China historically, of course, have been very much based on statutory law in some way. And now, gradually, the Chinese Supreme Court, the name is the People's Republic Court, something, I'm sorry, I forgot the name of it. Anyway, the Chinese Supreme Court has now stepped up and produces some kind, like the Brazilian Supreme Court also does. In Brazil, they're called súmulas, which is not really a case, but a synthesis of important cases, looking like a rule that you would typically find, a bit lengthier though, but that you would typically find in a statute. And something quite similar is happening in China. Now, what are these súmulas? Are they case law? Are they statutory law? And who gave them the mandate? Quite unclear. Who gave the Chinese Supreme Court the mandate to create these rules? France, for instance, has since the days of Napoleon, from what I understand, been very reluctant to give power to judges. They don't, the idea of power of judges making law is terrible. But what it has turned out in France, gradually, without any big reform, but gradually, like the development in Sweden, we see how the French Supreme Courts, what they do, their decisions become more and more important. And my French colleagues tell me that France, in this respect, has become inspired by the European Court of Justice. Because how European law develops through case law, that has served as an inspiration, probably, on how precedents develop in, as it gets increased importance in France. And this development, from a comparative law point of view, is interesting, partly because of how precedents gain increased importance in different ways. For instance, by a reform in the constitution, as in Brazil, or creepingly, like in Sweden and France. So that is, of course, interesting to compare how precedents become more important. But I'm more interested in the substance of law. And this is how this project, the Common Core of European Private Law, becomes interesting. Because when rules are created by judges, will that enhance harmonization of law? Or will every national jurisdiction become more and more nationalistic? So we create disharmony. I think that there is a great risk, and I think that is something negative, that the more judge-made law we have in a jurisdiction, the more nationalistic it will become. Now, I think that's bad, and that's why I think all of us have a responsibility to make the comparative law findings more easily accessible to judges making decisions. And I look now at this community, the Common Core the Common Core of European Private Law community. It's a small community. We like each other. We talk to each other. We close ourselves. I've been involved in other very interesting projects comparing comparative law, such as the study group for European Civil Code. Extremely interesting. We were very tight, a big group, but very tight. Looking at each other, communicating only with each other. I think for the comparative law communities, it is extremely important that we communicate outside our little group. That we bring home to typical nationalistic colleagues the findings that we've made in the comparative setting. So that we influence the textbooks for the students by hinting about other probable solutions, by pointing to the core, the underlying core, not only the structure of law, so that the judge, when the judge is going to decide a rule, by making a decision in the individual case that provides guidelines for the future, that judge gets easy access to the situation in other countries and get inspiration from that more than how a rule fits into the surface structure of the sources of law in that nation. Yes, and it is of course frustrating that this development will be so slow. You write a couple of sentences in a textbook now, you teach a little bit to the students now, and it will be some 50 years or 40 years before the student become a Supreme Court judge and make any difference. So this is a very slow process. But nevertheless, I think it is an important task for us to influence our nationalistic colleagues, and particularly the young students. It's slow impact, it's creeping harmonization, but still very important. And as we were reminded this morning, this is, of course, particularly important, not to be afraid of foreigners and foreign law in these times when we're all afraid of a new big war. So now, Alexander, maybe you can say something about the development of German precedents.
Thank you. Thank you very much. First, I have to start my presentation. Okay. So, I don't think that I'm in a position to stop wars here, but I hope I can bring something to the discussion on the relationship between private law, public law, regulation, things like that. Dear members of the organization committee, dear Kelly, dear, here in my text it still says, dear Mr. Chairman, so dear Ms. Chairman, so your second head, and ladies and gentlemen, thank you very much for the invitation and the opportunity to share with you some of my research on the interplay of private law and regulation. This is a field of research I've been working on for more than 10 years, but my focus has been mainly on German law and on the influence of EU law on the national legal systems. However, as this is a functional analysis of law, its results are not limited to a specific legal system. The relationship between private law and regulation has many facets. Therefore, I would like to start by exploring the terminology and underlying concepts a bit more closely. Subsequently, I will analyze different types of regulation by means of private law. First, the regulatory use of private law by the state. And this includes courts and case law as well. Secondly, such regulation which obliges the private addressee to regulate other parties by means of contract law. Finally, the question will be whether regulation can also occur in the relationship between private parties without any state interference. When dealing with the relationship between regulation and private law, the question inevitably arises which role the state plays in this context. Traditionally, the term regulation refers to state measures taken by the legislature or the authorities in pursuit of public interests. Thus, regulation, first of all, has a sovereign connotation. It is about measures that belong to public law. This connotation becomes particularly clear in the area of so-called command and control regulation, as expressed first and foremost in criminal law. However, the classic area of regulation goes far beyond command and control regulation. Since the New Deal, the US has had a large number of independent regulatory agencies created and supervised by Congress, whose task is to regulate certain areas of economic life. The industries subject to such regulation are accordingly called regulated industries. A classic component of this regulation is oversight of pricing in industries that serve the public interest or are otherwise closely related to public welfare concerns. In contrast to command and control regulation, this is not a matter of prescribing certain rules and imposing sanctions for violations. Rather, it is a principle-based approach that aims to accompany economic processes and to steer them in the sense of a common good orientation. This type of regulation, however, provokes the possibility of regulatory capture and was therefore at the center of the deregulation discussion of the 1980s and 1990s. Also in the EU, this kind of regulation exists. For example, in many areas of public services, such as telecommunications, there are directives that subject the access of new entrants to the market and the pricing of network infrastructure, such as telecommunication networks and rail networks, to close regulatory supervision. This type of law is sometimes referred to as regulatory law and initially has little overlap with private law. If one understands regulation as a synonym for this type of law and reduces it, in essence, to governmental price control, there is even a stark contrast to private law. This is because private law traditionally leaves pricing to the contractual freedom of the parties and merely controls the conclusion of the contract, that the conclusion of the contract was not influenced by mistake, deception, or duress. For some time now, however, the concept of regulation has been understood much more broadly. As early as 1989, Lawrence Lessig presented his concept of indirect regulation. According to this concept, the addressees are not only subject to the influence of law, but also of markets, social norms, and what he calls architecture. This refers to circumstances in the real world that constrain our behavior, such as the fact that certain places can be only reached by car. The crucial point now is that law can regulate the addressee not only directly, but also indirectly by regulating the other factors, markets, social norms, and architecture. For example, I can enforce a speed limit on a highway not only by command and control regulation, but also by prescribing that only cars with a technically implemented maximum speed may be allowed. In contrast to indirect regulation, in the context of indirect regulation, private law has also a certain importance. This is obvious in the regulation of markets, which is not only possible by means of public law, but also by means of private law. One example is the right of withdrawal in online selling, which guarantees every consumer the possibility of comparing prices and services after receiving the goods. But private law can also influence the content of social norms. For example, empirical studies show that social acceptance of homosexual partnerships increased enormously after the legalization of gay marriage. This is an example of what Kassanstein has termed the expressive function of law. However, indirect regulation still comes from the state. In contrast, the concept of regulation has been extended beyond the state for some time. Julia Black, for example, advocated a decentered understanding of regulation as early as 20 years ago. According to her, regulation can be defined as the intentional activity of attempting to control, order, or influence the behavior of others. This means that any reference to the state is abandoned, and private individuals can also act as regulators. The contributions by Fabrizio Cafaggi and Lisa Bernstein mentioned in the concept paper for this conference, which examine the ordering of international supply chains and industrial sectors by means of private contracts, still describe varieties of regulation according to this understanding. When it comes to questions of definition, there is naturally no right or wrong. Only considerations of expediency play a certain role. Personally, I believe that it dilutes the concept of regulation too much if one abandons any reference to the state. Regulation would then become a synonym for steering behavior. There is no doubt that control and steering of behavior is an important element in the definition of regulation. On the other hand, not all behavioral control is regulation. Every time we walk through the city, listen to the radio, or surf the internet, advertising posters, commercials, or algorithms try to steer our behavior in a certain way. According to Julia Black's quoted definition, that would all be regulation. Now, of course, you can say that these are not legal instruments. That's true. But is all legally based behavior control the same as regulation? Contractual penalties, for example, certainly also have the goal of encouraging the obligated party to fulfill the contract properly. So-called smart contracts, which aim to ensure contract fulfillment beyond the state court system, for example by means of blockchain technology, also have extreme steering effects. In my opinion, one should nevertheless not speak of regulation in all these cases. What all the examples listed under the classical concept of regulation, but also under indirect regulation, have in common is that they are concerned with the enforcement of public interests. In my opinion, one should only speak of regulation if there is such a connection to the public good. Otherwise, the term seems to me to become arbitrary and interchangeable. If, however, regulation is limited to the enforcement of public interests, this also results in an implicit reference to the state. For in a democratic state, it is primarily the task of the democratically legitimized legislator to define the public interests that the law, we can now say regulation, is supposed to help achieve. At the same time, the tension between regulation and private law can be defined more precisely. According to the traditional understanding, private law serves solely to balance conflicting interests between different private parties. According to Opium's famous delineation theory, private law serves private interests, whereas public law serves public interests. My own engagement with the topic of this conference started exactly at this point. In my habilitation thesis, I tried to show that private law belongs to the legislator's regulatory toolbox just as much as public law or criminal law. In other words, even if one follows a traditional, strict definition of regulation, private law also belongs to the regulatory toolbox. In my view, regulation is best understood as a function of law that transcends the demarcation of legal domains. In this regard, regulation describes the use of law as a governmental instrument with the intention to achieve general steering effects in order to pursue public interest goals. Regulation is then not to be distinguished from private law, but from other functions of law. These are, for example, the function of balancing interests, which plays a role beyond private law as well, and the function of infrastructure. At this point, just a small side note. If one sees regulation as a function of law per se and of private law in particular, this also offers a way out of another dilemma. Private law is not just another garden variety mode of regulation, as Hanak Dagan and Avihai Dorfman have countered a regulatory view. Rather, private law fulfills a variety of different functions. The balancing of conflicting interests as a core area of private law does not lose its importance by the fact that other parts of private law are used for regulatory purposes. What is meant by the regulatory function of private law is best demonstrated by examples. In German law, the legislature has recently used private law primarily to pursue sustainability goals. For example, the tenant may not reduce the rent for 3 months if the landlord carries out a renovation of the apartment to make it more energy efficient. Also, the installation of charging stations for electric cars in apartment buildings can no longer be blocked by the landlord or individual apartment owners. These rules clearly no longer serve to balance conflicting interests. It is true that the balancing does not mean that the legislator always seeks a middle solution. This is shown, for example, by the rules on employee protection, which in Europe often protect the interest of employees at the expense of the financial interests of the employer. However, the fact that the landlord receives the full rent, even though the apartment can only be used to a limited extent during renovation, does not serve to protect landlords, but is intended to improve the energy efficiency of residential buildings. Actually, there's an implicit link to the current situation. The fact that I, as a co-owner, cannot prevent my neighbor from installing a charging station in a shared garage is also not intended to strengthen my neighbor's private interests, but to help electronic mobility achieve a breakthrough. In the course of the enactment and implementation of the EU Sales Directive, the sustainability discussion has also found its way into sales law. According to recital 32 of the directive, ensuring longer durability of goods is important for achieving more sustainable consumption patterns and a circular economy. For this reason, durability was expressly elevated to an objective requirement for the conformity of the goods in Article 7. As an objective requirement, the criterion is also to be applied if the specific purchaser intends to use the item only once and therefore has no interest in its durability. In this respect, this is also an expression of regulation by means of private law. The Sales Directive provides a good transition to EU law. There, regulation by private law also plays an important role. This results from the special features of the Union legal order. The directives on European private law are regularly issued on the basis of Article 114 TFEU and thus serve the realization of the European internal market. This has an important impact on the interpretation and application of the national law transposing the directives. The aim is not only to achieve a balance of interests between the contracting parties. At the same time, the aim is also to strengthen the internal market, for example, by ensuring a high level of consumer protection. This is intended to encourage consumers to buy from suppliers in other member states as well, since they can be confident that both the conclusion of the contract on the internet and the performance of the contract, and in particular the handling of defects, are subject to the same rules as for a local purchase. In particular, the ECJ emphasizes in its decisions the goal of ensuring a high level of consumer protection. However, this is not a social romanticism to protect immature consumers. Rather, it is about the signal effect, we were already talking about, that a judgment and private law in general send to future buyers or consumers. If case law sends the signal that consumers are protected from unforeseeable costs, this strengthens the willingness to purchase goods even beyond one's own national and legal borders. This, in turn, increases consumer demand as a crucial component of the European internal market. The last part was already an example of what Hans Wolfgang Michlitz and his collaborators have termed European regulatory private law. In my view, however, at the heart of this development is a trend initiated by the ECJ with its case law on damages liability for antitrust violations. The use of private law to enforce public interest-oriented acts of union law. In this respect, there are, in my view, two main rationales. On the one hand, there is the approach that the ECJ established in Courage. According to this line of case law, the full effectiveness of the Union legal order may require that violations of European primary law gives rise to claims for damages because and when such claims for damages strengthen the working of the Union law. In the Munoz decision, this approach was also extended to European regulations. The ECJ is, however, more cautious about deriving an obligation to pay damages from the effectiveness principle in the case of directives that do not explicitly provide for claims for damages. The second approach from which a duty of the member state to use private law for the enforcement of union law may arise is complementary to this. The starting point is the protection of individual rights, which the ECJ has already recognized in the fundamental Van Gent and Loos case. As the ECJ explained, the vigilance of individuals concerned to protect their rights amount to an effective supervision in addition to the supervision entrusted to the diligence of the Commission and the Member States. The crucial point here is, however, that the mere existence of an individual right does not say anything about the way in which it can be enforced in national law. In this respect, the ECJ considers any proceedings under administrative, fiscal, or civil law to be equivalent. The person concerned must only have the right to have a possible infringement of his individual right and thus compliance with the union law reviewed in court proceedings, which at the same time open up the possibility of a referral procedure to the ECJ. However, it is initially up to the procedural autonomy of the member states whether they grant a private legal remedy or legal protection involving public authorities. In some cases, however, there are implicit decisions in the laws of the member states. German law, for example, contains a provision according to which the German Financial Market Supervisory Authority acts exclusively in the public interests. This precludes investors who believe that listed companies have violated their investor protection obligations under EU law from suing the authority in order to force supervisory action. In such a case, member state law must then provide the affected investor with a private law remedy, typically a claim for damages against the potential EU law infringer. These examples should provide a brief overview of the regulatory use of private law by the state, especially by legislators and courts. In particular, the requirements of EU law that I mentioned last have, in my view, the potential to become a common core of European regulatory private law. Nevertheless, one must not lose sight of the fact that this is a special case. Private law is also increasingly used for regulatory purposes beyond the requirements of EU law, and in this respect competes with administrative and criminal law. However, the legislator does not only have the possibility to use private law as such for regulatory purposes. It is also possible to regulate companies in particular in such a way that they are obliged to pass on by contract certain obligations to the actual addressee of the regulation. Examples of such a regulatory technique can be found on the one hand in complex economic organizations. For example, banking regulation requires banks to establish a comprehensive internal compliance organization, the objectives of which are specified in detail by the regulation. On the other hand, this regulatory technique can be applied in the field of transnational business law, for example, to enforce so-called ESG, that means environmental, social, or governmental concerns in international supply chains. This regulatory technique is sometimes referred to as regulated self-regulation. First of all, it is regulation in the traditional sense, in that the primary addressee of the law is to be induced to act in a certain way by means of state law. Interestingly, this can be achieved by means of public law as well as private law. For example, the bank's organizational duties are prescribed by classical banking supervision law. However, a responsibility to comply with ESG standards can also be imposed under private law. For example, the ultimate seller can be made responsible under sales law for ensuring that the good was produced without the use of child labor or in compliance with certain environmental standards. The necessary connection to private law only arises at the second level. Here it is a matter of the primary addressee of regulation passing on the requirements to the other addressees of regulation under private law, be they employees or suppliers in a supply chain. This is an encroachment on the contractual freedom in that the primary addressee of regulation is forced to conclude contracts with its employees or suppliers with specific content and, if necessary, to monitor compliance with them. Thus, contract law is not itself a medium of state regulation, but is used independently by the private parties. However, if they do not conclude appropriate contracts or do not adequately enforce them, there is no sanction within contract law. Rather, the primary regulation at risk is then subject to the sanctions resulting from the legal regime that establishes its obligation to self-regulate. In extreme cases, a bank can lose its license and be forced to wind down if it has a deficient internal compliance organization. The consequences chain leaders face for deficiencies in their supply chain depend on how the obligation to self-regulate is established. Buyers' warranty rights only have regulatory potential if they can assert them without great effort within the framework of collective redress procedures. This is particularly true if the breach of duty is not reflected in the lower quality of the good, so that only those buyers who have an idealistic interest in compliance with the relevant ESG standards will become active. It is important to note, however, that this type of regulation only works in transnational contexts if it applies to a sufficiently large market. Otherwise, local chain leaders would be squeezed out of the global market due to the increased compliance costs resulting from the regulation and replaced by sellers from third countries that are not subject to any corresponding restrictions. If, however, the EU issues such rules of mandatory contract law for the entire internal market and extends the responsibility for compliance with these standards to importers as well, an entire industry, or at least a significant part of it, can be regulated in this way. As I said at the outset, I'm personally skeptical of those approaches that seek to extend the concept of regulation beyond the involvement of the state to the relationship between private individuals alone. Private individuals, and specifically private companies, pursue private interests, often profit interests. Actually, in my view, there's nothing to say against it. It is obvious that they want to control the behavior of other persons and also use legal means for such control. Let me remind you once again how we are all controlled when using search engines or online stores on the internet by means of subtle algorithms. From a legal perspective, the task here is often to put a stop to excessive control or monitoring by providers with market power, at least when the customers or consumers concerned have no sufficient alternatives on the market. In this respect, attempts are currently being made to use antitrust law to force quasi-monopolists, such as Facebook, to offer alternative forms of contract, specifically paid access but with fewer personal data being processed. On the other hand, however, there are also approaches to treat particularly powerful providers as state-like and thus subject them to fundamental rights. For example, the German Constitutional Court has ruled that operators of football stadiums cannot invoke freedom of contract with regard to admission to stadiums. Rather, they are bound by the general principle of equal treatment under Article 3, Paragraph 1 of the German Basic Law, and therefore require an objective reason if they do not wish to admit a certain interested party to the stadium. This fundamental right also imposes a duty to clarify the facts before banning a person from a stadium, to hear the person concerned and to justify the decision to refuse in such a way that effective legal protection can be obtained against it. These obligations are directed at private football clubs. They concern the relationship of these private clubs to other private persons, the potential stadium visitors. Similar duties directly arising from fundamental rights are discussed for the operators of social networks. The main difference to the previously discussed constellation of regulated self-regulation is that there is no state regulation here. Instead, stadium operators or social network operators are subjected to duties and limitations resulting from the purposes of the state itself, solely on the basis of their de facto position of power. They are treated as equal to the state. However, this raises the question of whether the responsibility they are thus given does not also mean that the contractual rules they set should be regarded as regulation. In practice, this becomes particularly relevant in the case of legal protection. In the German legal system, the obligations of stadium operators to clarify the facts of the case, to hear the persons affected and to justify their decision as laid down by the Constitutional Court can only be enforced in civil courts. However, these are classic rules of administrative procedure, and the civil courts are not in a poor procedural position to monitor or enforce them. For example, the German Code of Civil Procedure does not provide for ex officio investigations, which is the daily bread of the administrative courts. In countries with a uniform court system, such as England and Wales, this presents fewer difficulties. There, the civil procedure rules contain a section entitled Judicial Review, which deals with the judicial review of sovereign acts. With reference to these rules, the plaintiff in a legal dispute between two private parties can also claim that the defendant has committed a decision, action, or failure to act in relation to the exercise of a public function, and is therefore subject to judicial review. In a leading case, the issue was the extent to which Birmingham International Airport Limited exercises a public function in this sense, which was denied for the award of contracts to cab companies. With such an approach, one would conclude from the legal consequences, in particular from the possibilities of legal protection, that a private party had acted in a regulating capacity within the framework of the contracts it had concluded. Personally, I have reservations about extending the control possibilities of public law, such as fundamental rights or judicial review, to the conduct of private parties. There are often adequate solutions within private law. For example, the EU's Equal Treatment Directive prohibits discrimination against private individuals in access to and supply of goods and services which are available to the public, including housing. According to this directive, however, discrimination is only prohibited based on racial or ethnic origin. A similar directive prohibits discrimination based on sex. Put another way, this means that private parties are not prevented from determining their contractual partners according to other criteria, and, for example, for not allowing fans of a certain football club to attend the football stadium. If the constitutional requirement of equal treatment is extended to private individuals, this differentiation is overplayed, because any selection decision then requires an objective reason. In this way, the differentiated obligations of private law are leveled by constitutional law. Let me conclude. I have tried to show that there are many connections between regulation and private law. At the beginning of my talk, I argued that we should speak of regulation only when the rulemaking originates in the state and is directed to the pursuit of public interests. Even within private law, however, a distinction must be made. Private law, in the true sense, always emanates from the state, from the legislature or the courts. Private parties who conclude contracts make use of private law, but do not create any law themselves. They rather establish contractual obligations within the applicable private law. For this reason, too, I do not believe it is appropriate to elevate such contractual obligations to the status of regulation. Thank you very much for your attention.
Thank you so much, Alexander, and thank you so much, Christina, for two very interesting topics. And now I'm going to try to say a few words in my capacity as a commentator, so I put on my commentator hat. But I think before I start to talk more specifically about your two presentations, I want to connect a little bit more further back of this conference and go back to what was discussed during Professor Ugo Mate's session. The importance of comparing. I think that I actually added this point just this during the lunch break, because I think it was such an important reminder what Professor Matea talked about, the great legacy of comparative law in general and the Common Core project in particular. The importance of comparing the long history of comparative law and the long history of this Common Core project. And I do believe that this is a legacy that, the future generations, the younger generation comparatists need to manage with great care. And me, myself, I come from a commercial law and more specifically financial markets law perspective. And I would like to say that it is perhaps more important than ever to compare in this very globalized financial markets. Because when it comes to the regulation of the international financial markets, I would like to argue that comparative law has not only changed, adapted to the changes of globalization in order to survive, in order to be, still relevant. Rather, I would say that comparative law has thrived in this era of globalization. What comparative law can bring to the table when it comes to the regulation of the international financial markets, but also, I believe, in other areas as well, is that comparative law stands at the intersection between the global and the local. It can show, it can identify the similarities and differences between various legal systems, but it can also reveal the legal, political, economic, and cultural context that these regulations are deeply embedded in. So, comparatists, we must have a thorough understanding of the trends that are towards the global, the universal, but as well, the diversity and particularity of the very local. So I think that in the regulation of global finance, comparative work, it is not only a significant contribution, but it is even one of the missing puzzles in this equation. And it is also from this commercial law, global, international commercial law perspective, that is my point of entry in terms of my comments to you and questions. And if I could start with Christina's topic, first of all, you know that I'm very interested in this topic because I've followed the Guiding Cases project by the Supreme Court in China. And it is SPC, Supreme People's Court. So, and I know that you're part of a major comparative study of comparing precedents in China and Sweden and several more countries. But before we talk a little bit more specifically about the differences and similarities between the legal system that you have looked at, I think when talking about this topic, it is inevitable, to talk about the relationship between judges and the legislator, and the discussion of judicial activism. So I think that will be my first point that I would like to hear more from you, if you could develop your thoughts about that. And then My second point is that I would love to hear a little bit more about your thoughts on how the world of international arbitration comes into play in this judgment law topic of yours. You know, and also it would be wonderful if you would like to, pack this very neatly into the theme of our conference, law at the center or periphery of regulation. Where would you place them, these norm setters? And lastly, to make things a little bit more complicated, is that I would like to hear your thoughts about these judges, these norm setters, that are judges in these specialized commercial courts. So in China, for example, they have established specialized commercial courts that's actually a part of the national court system. But these courts are specialized in international commercial disputes. And the construction is such that they have judges that are Chinese judges, but they also have a panel of, I think it's called international consultants or something like that. And these are essentially lawyers, judges, and different legal backgrounds that are experts in international commercial disputes. They are not judges, they're not allowed to make any rulings, but they do have quite a part, as based on my understanding, in these commercial courts. And where would you place them then in this judge-made law, legislator, law at the center and the periphery of regulation? I do have a few more points, but I think it will be a good start to I will not. And what will be easier if I make my comments and maybe to you, Alexander, as well, or shall we take it? Yeah. Okay.
Just for you.
But I think then I can also just say my.
Maybe it's better because now people still have your questions in mind, right?
Yeah.
So that
Absolutely, definitely.
if you react to that directly.
Yeah, I don't know, Kelly, whether I should say thank you for your questions or not. Now, the question, the judge-made law, of course, we have then the debate, how activist could a judge be? What is the judge's mandate to create new rules? And this, I think, is a deeply cultural issue, and it is connected to what amount of trust we put in the persons that we have appointed as judges. Now, luckily, within my area of law, private law, this is not a big issue. Since private law, somebody named private law the lawyer's law. It is uninteresting for politicians. You don't win any elections by stating, I want this rule for private law, apart maybe from consumer law, the consumer law area. So I don't think we need to worry too much about judicial activism, the active judge creating two revolutionary rules within the area of private law. It is, of course, much more controversial within the public sector. The second issue, you asked me questions about arbitration and international arbitration. And here, to my experience, the arbitrators who are often involved in international disputes, often hearing arguments from councils from various countries, they gradually become a-national. They should, of course, apply some applicable law. So, for instance, the law applicable to this dispute is Swedish law, and they should look into Swedish law, and they should have Swedish experts to be heard on Swedish law. However, I think this was also very interesting what Hugo Matteo said this morning, that Rudolf Schlesinger was a truly bi-jurist, I think he called it. He said that he was totally familiar both with German and US contract law. But typically, an arbitrator is not such a super person. So even if the arbitrator applies Swedish law, the arbitrator will inevitably be influenced by his or her own national law. And your question was, what is comparative law? How is it relevant for arbitration? It's very, very relevant. And I think that most international arbitrators will be very open-minded towards rules in other jurisdictions. And to be counsel for a party in international arbitration, I think that awareness is extremely important. You cannot communicate with, for instance, a Swiss arbitrator unless you are somewhat aware of Swiss law, even if Swedish law is applicable to the dispute. And then, Kelly, your third question, norms at the center, periphery of regulation. Remind me, what kind of norms?
No, these norm setters. So you talk first about judge-made law. Based on my understanding, there are, judges in the national court system, judges, especially Supreme Courts. So we have these norm setters, but then we also have the international world of arbitration, arbitrators. And then I want to ask you about where would you place these norm setters that are, I would say, at the intersection of the international arbitrators and national judges, these specialized commercial court judges and consultants. Where would you place them, at the center and the periphery? Just to make things a little bit fun.
I would put the arbitrators in the very periphery, because arbitrators don't create any norms whatsoever.
Okay.
And even if there is some kind of community among international arbitrators, knowing each other, understanding each other, they are too diverse to create any homogeneous body to create rules. Whereas a Supreme Court typically slowly develops by gradually replacing one judge for another, and they feel also a responsibility to create rules, which arbitrators don't. Some arbitrators, of course, perceive themselves as gods, but only gods in the individual disputes, I hope. So definitely arbitration out in the periphery of creating norms. And then your final, fourth question referred to the possibility for Supreme Courts to bring in experts. For instance, experts on what is the law in other countries. And from what I understand, very many Supreme Courts throughout the world, they have this possibility to ask for advice from the outside, although it's very rarely used. But very many jurisdictions have some kind of possibility to assign experts. And that is, of course, good. Because if I were a judge, knowing that I need to create a new rule for an uncertain question in Swedish law, I would like to know, how has this matter been solved in other jurisdictions? It would be very valuable knowledge to me. So maybe we will see in the future more frequent use. Not, as I understand, in China it is institutionalized and de facto used. And maybe we will be inspired by the Chinese in this respect and do it more. I think that would be a very good development.
I'm very fascinated by what you're saying about arbitrators, that they do not set any norms and they have no responsibility to create any norms. very fascinating, because I wonder, so they have no role in, for example, Lex Mercatoria?
The arbitrators, they don't create law. They don't create norms, but they kind of apply the Lex Mercatoria. That's how I'd see it. And this is why, for legal counsel, arbitrating in front of a foreign arbitrator, he is well advised to look into the UNIDROIT principles and communicate with the arbitrator through the UNIDROIT principles. And this is how they become influential. But not as the arbitrators are not creating norms.
So they're softer than soft law.
Softer than soft.
Yeah, and definitely not at the center. They're not even in this puzzle. Thank you so much. I think a lot of more questions, and I'm very sure that the audience has a lot of questions as well. So I think actually we're going to stop this discussion between us, and I will move on to my comments to Alexander. But this is not the end of our discussion, I'm pretty sure, Christina. So I think it's quite clear, my perspective, where I'm going to come in, and the view of my comments. And I think I'm going to have this similar approach when it comes to your topic as well, Alexander. Again, many interesting, fascinating points, but I'm not going to cover all of them. One thing I think that I thought that because you talk a lot about EU law, but based on my understanding, EU law, different from many member states' law, is not based on the idea of private-public divide at all, right? But the idea. Not based at all. So it's not a guiding principle. It doesn't function that way. Yeah. It works on the on the delegation conferral competence between the member states and EU and so on. But private public law is deeply embedded in many of the member states' legal systems. And I do absolutely agree and fully aware of that this whole idea of a private-public law divide, it doesn't really exist in reality. The line is very much blurred. But this idea of private-public law divide, yes, I would say still shaped a lot of, mindsets. Because that's what you learn, that's the systematics you learn from law school, from the very beginning. So in that sense, I do think this private-public divide is still relevant to talk about it. So essentially, private-public law, there's no divide in EU law, I understand, but this maybe not fully when it comes to the national legal systems. So maybe a little bit on that. I would love to hear your thoughts. And my second point is that coming from the financial markets law perspective, I think you mentioned banking law, and I fully agree that when it comes to the regulation of the financial markets, EU has been very active. Since the financial crisis of 2008, especially, the amount of EU regulations in the financial markets is, I don't know, numerous wouldn't be enough to describe it. And this has, of course, reshaped the regulatory frameworks of the member states, but it has also had a deep impact on the private law in the member states. Just to give you an example, which I think you are fully aware of, for example, contractual relationships between the financial advisor and its clients, between a bank and its clients, and so on. And this is, I think, has been referred to as the EU regulations falling as an eclipse over the private law of member states. But what I think is more interesting in this development is the idea of prescribing upon a private party the obligation to serve public interest. Because that's what happens when you have these EU regulations affecting the contractual relationship. What they do, a bank is not longer obligated to serve to protect the interest of its client, but it's also the public interest. So here, I think I want to hear what you think this kind. Should it be so that private parties are prescribed upon this, duty to serve public interest? That's, I think, I would love to hear more from you about. And the very last point, again, the Institute of Lex Megatoria. Because if we start from the final comments of what you just shared with us, then could you say that, is it so that Lex Megatoria, its very existence is just because the legislator allows it, It exists at the mercy of the legislator. Or is it, is an exaggeration of your ideas that you just shared now? Yeah, I think I'm going to stop here.
Okay. So then I also move back to here. So thank you so much for all these interesting questions. Actually, some of the questions you posed to Christina also made me think about things, and I think the last question you just asked me also has some connections to that, so I can maybe bring some things together. And this concerns the question of judicial activism you asked, Christina. And I think it has to do something with the Lex Megatoria question. Because in my view, it heavily depends what kind of court we are talking about. And so the first thing here would be that what is the role of this court in the legal system, and how easy can the legislator change these precedents or these cases, this case law, which you could term judicial activism. So, for example, on the EU level, there was kind of a problem with this at the early stages of damages liability for the infringement of antitrust law, because this was all developed by the interpretation of EU primary law. So, in theory, this was all an interpretation of primary law, so it was not up to the normal EU organs to change this. So it would have required a change of the contracts by the member states in order to really change this. So, for example, like the basic decision that there has to be a damages liability. So if this is interpreted into Article 101 Treaty of the Functioning of the European Union, then it's not, you cannot have a directive prohibiting these damages. And so this can lead to an imbalance of the system, and that's problematic. Whereas if you have like a normal court interpreting simple law, so no constitutional law, no primary law, then it's much easier for the normal legislator to change and to react here. And so in that case, especially if there's been for a long time no action of legislators, I think it's more appropriate, and I don't have any problems with judicial activism, because the legislator can react to this, and very often does if something like that happens. And so that's the thing. If you go to the international level, then the problem is also, so that connects to another thing you asked. Let me see my notes. Yeah, I mean, if it's really tied to some public interest. So if we want to speak about regulation, and so in my view, you could also have case law setting kind of regulations here. But then if you have this connection to the public interests, but this becomes much more difficult once we enter an international level. And I mean, in the EU context, we still have some common framework, but this is also very special, tied to the goals of the EU. So that's what I wanted to show. That so if we want to implement the political goal of enhancing the internal market, then it's within the system. If we suddenly wanted to, if the ECJ wanted to implement some other political goals, there would be a lot of problems and difficulties to implement this. And so if you come to the really international level, then I think there's no consensus about any public interest goals that all the countries share. So because these public interest goals are still quite national aspects, at least very often. And there's a lot of disagreement on the international level. I mean, between market economies and more centralized systems and things like that. So there's a lack of a common ground on which you can regulate here. And I think that's the reason why the lex mercatoria is very defensive and only like trying to write down like parts of the law where we can find a agreement and where we can find some guidance, but this is not regulation in my point of view as well. So I would, coming from a different perspective, I would agree with the conclusion that it's very not in the center of regulation, but it's very far apart. And so you ask about EU law, and I already said something about that. So the divide, so the divide between private and public law. So in my view, EU law can really serve as an engine to overcome this in a certain way, because it shows us, and that's also something which comparatives know, that you can find different solutions for the same problem. And different does not only mean different within private law, but it could also be public law solution or a private law solution. And so it's interchangeable to a certain extent. And this is something we are being made aware of by EU law. And the ECJ is very consequent in just treating these ways all equal, and I think that's the right thing. But of course, you're right that it still shapes our mindsets, and so this is something. I mean, even in EU lawmaking. To give an example, which also goes to the next question you asked me. So after the financial crisis, the EU very much tightened sanctions in capital market law. And so there was a commission, I think, green paper, white paper, and some other plans and proposal about a new sanction regime and capital market law. And it was also in the end implemented by having these huge fines, which we only knew from antitrust law before, now in capital market law, and later on also in data protection law. But this was all concentrated on measures of public law and criminal law. So we even have a directive for criminal sanctions in market abuse law now, and we have these huge fines, but there was no word at all in this paper about private law as an instrument and as a sanction. And I've been criticizing this already before this was implemented, and I think the answer why this happened is not that the EU doesn't like private, or the Commission doesn't like private law. It's just the mindset of the people working there. So they have always dealt with public law sanctions, and it's also, I mean, it also has this this legend that you get in trouble once you try to introduce something which would be implemented by means of tort law, because tort law is so diverse and we don't know it, and the member states resist to something there, and so we rather don't do it. So I mean, even in capital market law, so prospective liability, all these, so where you have private liability rules, they are very, very general. Even in the regulation, it says that the member states shall ensure that at least, and so on, and their national laws apply, and blah, blah, blah. And so it leaves open everything, and you can do whatever you want. And so there's no really harmonization here, and that's because they are afraid of private law. And so that's kind of a problem, because it's not, at that point, it's not treated equally, and I think that's the problem of the mindset which you mentioned. So I would agree in that. And so to come to your last point, so the kind of infringement of EU financial market regulation on private contracts between banks and their clients, so that's a really interesting field. So in my view, there's nothing against which speaks against this goal to make private persons act in a public interest way, if you do this by means of normal law. So I have problems with what I said with applying fundamental rights to private parties, so obliging them to fulfill the requirements of fundamental rights. But if you do this by way of simple law, that's nothing to say against, I think, because, I mean, that's kind of the consequence of privatization. So if the state doesn't fulfill all the public interests itself, so if the state doesn't provide you with credit or with water supply or whatever, but leaves this up to private companies, then still it's legitimate to regulate them in a way that they serve private interests within their business activities. And of course, they are free to follow their business activities and to be profit-oriented as far as they are allowed to, but you can have outer limits to that, and you can steer their behavior in a certain way to make them work in this way. But the question still is whether this is a question of private law. So I personally would agree, and I think that it's really meaningful to do that also in the contractual law. But the interesting thing is the more the EU enhanced these duties, so some member states pulled out in private law. So, for example, the German Supreme Court really changed its case law here. So, in the beginning, when we had this 1993 directive, they really interpreted the contractual duties in the light of the directive at that time. And then even the directive wasn't even transposed, and they already referred to it for guidance. And then when MiFID I and MiFID II came on, they suddenly changed their case law and now say this is all a matter of purely administrative law. It has nothing to do with the duties of private parties. And I mean, the German legislator sometimes stepped in and said, for example, that the duty to keep records for the banks also gives the right to the private party concerned to request these copies of these records in order to prove their claims for misleading investment advice and things like that. But this is seen as like a official implementation of this divide at that point, because there you have a private law duty, and so we can infer that all other duties only belong to public law. That's the position of the German Supreme Court, which I think is completely wrong, but because, I mean, you have these overlying duties, and they evolve from contract law. That's the funny thing, right? I mean, this is something we had in commercial contracts all the time, and now the EU has, in an American-style fashion, wrote this down like in a 200 pages contract, which is now called regulation. And but it's, I mean, this is still the same. It's the duty to act in the best interest of your client. And so, yeah. So let me stop here, because otherwise we won't have a coffee break.
Thank you so much. I think, Alexander, what I think it's really, really interesting is that we're no longer talking about, the interplay between private and public law. What we are talking about is the interplay between public interest and the interests of private parties. That's essentially, the more important point, right? I promise I will not say anymore, and we will have a coffee break. So 15 minutes, we'll come back at 4 o'clock. And then we will open up the Q&A part of this session. Thank you so much.
Thank you.